Can everybody hear me okay?
Good morning, Leonard.
Good morning.
You're a little bit light. You're
Is it getting any better?
Yes.
Okay. I found that with this microphone, it kind of adapts as I talk more. So if anybody at any time can't hear me, just let me know, obviously. So, Ms. Boulay, are you ready to go?
I am ready.
And Ms. Crane?
I'm ready.
Great. We are on the record in the Colorado Public Utilities Commission's proceeding number 25F-0270CP. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately 9 a.m. on December 11th, 2025, and this remote hearing is being webcast. This remote hearing was initially convened on November 18th, 2025, and then continued to today at the request of the complainant, Mr. Lysenko. This hearing was scheduled as a remote hearing in which the participants are participating from discrete locations. Decision number R25-0765-I that issued on October 24th, 2025 included instructions for participating in this remote hearing by computer or telephone. All the attorneys in any event, I think, have participated in plenty of discrete hearings here, so it's no shock that you've all figured it out. So with that, let me take appearances, starting with the complainant.
Thank you, Leonard. My name is Roman Lysenko, and I represent myself.
Great, thank you, and welcome, Mr. Lysenko. Let's go to the respondent.
Good morning, Your Honor. Sean Jennings, representing the respondent On Location Events, LLC.
Thank you, and welcome. And I see Mr. Valentine here. Do you want to enter your appearance and let us know who you're representing?
Thank you, Your Honor. Mark Valentine from Keys and Fox on behalf of Ace and Ramblin for the limited purpose of representing the two of those clients during their cross-examination.
Okay. So as noted, we convened originally on November 18th. I ruled on a couple of motions at that time, and then we continued until today. We're scheduled for one day. I'm assuming, unless anybody wants to tell me otherwise, that we're going to be just fine with one day for this hearing. Let me just ask, does anybody want to make an opening statement here today? They aren't typical in our proceedings, but I'm certainly willing to entertain the possibility if anybody wants to provide one.
Your Honor, before we move on to the evidentiary hearing, I would like, in the preliminary portion of the hearing, address one issue. And I'm not sure if there is an issue or not. So for a clear record, is it any way you can repeat what was the ruling on the motion to limit? What was exactly the scope of the hearing was limited to? Could you repeat, plus, because I did rewatch the video several times from the past hearing, and it sounds like it was inconsistent. We've been talking about advertising in general, arguing about advertising, focusing on the loss. And then within the last 4 minutes, kind of on that topic, Your Honor, you repeated the ruling, but you repeated with additional narrative verbiage, which narrows specifically for on location, not disclosing the fact. And I just want to see what was the actual ruling, if there is an issue, because if there is an issue, this is the right place and time to address that issue. If it was last minute inconsistent ruling, there is can be a motion to reconsider, for example, or motion to broaden the scope. And I want to see what if we need to go that route right now or not.
Okay, so give me a moment. I'm having some computer issues. Okay, Mr. Lysenko, so you're asking for me to repeat the ruling on the motion to limit specifically?
Yes. What's the evidentiary hearing limited to? So right now, so we don't go outside of the scope right now, just to make sure we have clean record and just to make sure we have efficient hearing. So I'm just asking what.
Okay, so at the November 18th hearing, as I stated on the record, I granted in part and denied in part the motion to limit. So I held that the issue to be decided is whether on location violated decision number R25-0406, which specifically found that on location's website failed to adequately disclose that it was a transportation broker, and that violated Commission Rules 6016 and 6202. I further held that the only evidence necessary in this proceeding addresses whether on location has failed to comply with Chief ALJ Adams' order to comply with the rules governing the advertisement of its transportation broker services. I also held that you, Mr. Lysenko, are permitted to go beyond the 20-day window on the back end that Mr. Jennings had asked to limit you to. In other words, the 20-day window in between the filing of Chief ALJ Adams' decision R25-0406 and the filing of your complaint in this proceeding. Therefore, in that sense, I denied the motion to limit and allowed you to go beyond that end date of when you filed your complaint. And then I also granted the request by Mr. Jennings in the motion to limit to take administrative notice pursuant to Rule 1501 subsection C of the documents in proceeding number 25F-0270CP, which I believe is the correct proceeding number for Chief ALJ Adams proceeding. So that was the ruling, granting in part and denying in part the motion to limit.
And Your Honor, just one thing. You mentioned, you pointed specifically that evidence needs to focus on whether on location compliant with the Chief ALJ decision order, ordering on location to comply with rules and statutes governing the advertising of its service. So you specifically specified that it has to be, the evidence should be narrowed to the rules governing such services. I assume this is still correct. Am I correct?
I'm sorry, could you repeat that again, Mr. Lysenko?
Yes, the statement was at the minute 54 and 30 seconds. Your Honor stated that evidence needs to focus on whether on location complied with Chief ALJ decision ordering on location to comply with the rules and statutes governing the advertising of its services. So basically, you stated that, yes, the decision found a problem with on location not disclosing, mainly. I'm not going to say that it was the only one, but mainly. And then, but you stated that on location needs to comply with the order, not show that it now presents the disclosure, for example. It should be the order calls for compliance with the rules and statutes. That's how the chief LJA focused it. And he, obviously, he's chief LJA, so he's not the using broader language only because he couldn't express himself better. Obviously, he knows the consequence of using broader language, and he knows how and when to use broader language. So I guess there is no need to deeply go and see what was the issue. But if we need to, I would love to present the evidences that the on location was in violation of two rules, actually 6016C and 6016B, which kind of leads to the 6016A violation and 6202A violation. But it was both violation, and 6016C doesn't have anything to do with the actually with the disclosure and notifying customers. And I did prepare because when I heard that last ruling, I did prepare the motion to reconsider. And I would probably love to present it just so we on the same page. And because the decision wasn't focusing only on location disclosure. It specifically, actually, LJ stated in paragraph 120 that when it's find out and saw the disclosure at Exhibit 205, he specifically stated that it's actually a good faith effort to attempt achieve compliance. But he didn't find that in compliance. He still ordered to cease and desist until on location compliance with the whole with the all statutes, because obviously the 6016C was left behind up there. So I just want to make sure we're not narrowing specifically to on location failure to disclose the fact of being a broker, because they're actually the 6016C violation, which was proven in the previous case and noted in the decision, it's going to be outside of the scope. So the previous decision is broader. Plus, I've got lots of legal arguments as well. May still present the motion to reconsider, just to broaden it to original ruling, which was advertising. That's what the on location asked. On location's advertising, and if on location compliant with the rules and regulations governing such operations. Your Honor, may I proceed with the motion?
Give me just one moment. I continue to have some issues. Just give me one moment.
May I respond to this, Your Honor?
Hold on one moment, please.
Thank you.
And if Your Honor will allow me, I will point exact paragraphs about 6016C violation in both decisions.
Mr. Lysenko, could you keep your voice up?
Yeah, yes, I apologize. I don't want to lean too close to the microphone because it gives the echo. But Your Honor, I said that if you will allow me, I will show exactly in violation of 6016C in both interim decision and recommended decision. And in the interim decision, the prima facie showing been made, and that showing is carried forward. And that's important to kind of see that interim decision as well. and I will show you both violations going through the both proceedings. I mean,
Okay.
both decisions.
Mr. Jennings, you'll be given the opportunity to respond at the appropriate time. Bottom line, Mr. Lysenko, you want to present a motion for reconsideration of the decisions or decision that I made with respect to the motion to limit at the November 19th hearing. Is that what you're looking for?
Yes, Your Honor.
And so it sounds like what you want to do is you want to present, but you correct me if I'm wrong, much broader evidence regarding on locations violations in your view of rules and statutes other than the ones regarding their advertisement of their services as a transportation broker. In other words, you want to try to prove that they have violated other rules. And I mean, do I have that right? You want to present much broader evidence, is that right?
No, Your Honor, not only, let's say that. So with that ruling, it was 5 different issues. First of all, the last ruling, which narrowed down almost to on location, not disclosure, the first problem was it was unsupported by the motion. So the motion was about the on-locations advertising. I argued about on-location advertising. Then at the previous hearing, you and on-location confirmed about that it needs to be narrowed to on-locations advertising. Then you made the ruling about that and specified. And then later on, it went much more narrowly. So my problem was that the ruling was unsupported by the motion. Secondary, that the ruling was prejudices the complainant because complainant never get the chance to argue on the actually such a narrative limitation. We've been arguing about on locations advertising only. So, but then last minute it went boom, like much more narrow. And I do understand that administrative law judges once in a while do limit the scope just by themselves, just to keep it efficient. But if this is the case, it's even more appropriate for this last minute ruling, this motion to dismiss, because it's actually your ruling and your interpretation was based off of the decision. And I never get a chance to state my arguments on that, and the decisions are broader. You're correct. You're much broader than just the scope that we narrow into right now. And plus, there is additional decision on the actually on the proceedings on merit was made when the LJ actually reviewed that decision. In that proceeding, the respondent heavily relies on locations decision as well, which is at the issue right here. And the Judge Rosenberg actually already went through that paragraph, and she actually also read it the same way I read it. And she also discussed that and made the decision based on that decision also already. And I can provide the decision number and the proceeding number as well. So
this is ALJ Rosenberg's decision that came out just recently within the last couple of days or so. Is that what you're talking about?
Yeah. Well, it was, yes. Yep, I believe on Monday. Yep. Yes.
Okay. So let me just interrupt for a second, Mr. Lysenko. Kind of like, well, what I would like to know is just what you're looking for precisely, and then I can understand that, and then better understand the arguments that you're making. So let's start at the end first and just tell me exactly what you're seeking from me, and then you can continue with your arguments.
I apologize. Your Honor, the relief from this motion to reconsider or broaden the scope of this proceeding, this evidentiary hearing, is to bring it back to the original ruling. And this is what the allocation asked for, to bring it to limit scope of this hearing to allocations advertising on its website. And if allocation complied with the order in the previous decision, which is part 3, which states to comply with all regulations and statutes and rules governing such operation. So that's the scope of the limit should be, without going narrowly into the problem whether allocation correctly actually disclosed itself to customers.
So do you want to limit the evidence to on locations advertising?
Yes, I do. That's no
Okay.
problem.
And then since Chief ALJ Adams' decision was issued, do you want to limit it to that date moving forward?
Yes, yes, I do agree on that as well.
Okay, so you agree to limit it to on locations advertising on their website, presumably. And is that right? I mean, that's...
Yes. Well, yes, but in an administrative law judge order, he said that the with the statutes compliant, on location should comply with the statutes, right? There is no, well, but if we need to, yes, that's no problem, and we can limit to the website. Yes, that's website. We can just leave it as is. But as long as...
Okay, and then okay, so what restriction do you want to get rid of that you think that I imposed?
I believe Your Honor imposed specific narrow restriction, narrowing even further to whether on location are properly disclosed itself to the customers being a broker, which limits even narrowly.
So that's what you want to get rid of?
Yes. Because it wasn't the only issue at the decisions. And
okay, so you want to present evidence of on locations advertising since Chief ALJ Adams' decision was issued. And that evidence is not limited to its advertising of itself as a transportation broker. You want to go broader. You want to focus on the advertising, but you want to present evidence other than whether they adequately disclosed that they were a transportation broker. Do I have that right?
yes, definitely. Because
okay,
it was...
Go ahead, Mr. Lysenko. I interrupted. I now understand better what you're looking for, so go ahead.
So am I allowed to go with the motion?
Yes.
Okay. Thank you, Your Honor. So I would like to, as I already brought up portions of this motion, I still want to go in details and present the evidence. So I believe that the final version of the ruling exceeds the relief by far. This was significant and unsupported narrowing of the issue that leaves proven violation of 6016C outside of scope, prejudices the compliant, and will lead to manifest injustice and incomplete record. So this is there is no issue with the notice. The complaint is clear. The unlocation didn't comply with the decision's order, and order is clear that the unlocation should comply with all rules and regulations governing such operations. The LJA, chief LJA, knows, like I said before, how and when to use broader language, obviously, and if he uses, that's what he means. So there is no reason to go deeply and try to find what was the problem and limit it to that, specifically to that problem. But even if we're gonna go and ignore the order, broader order, and we're gonna go and try to see what was the violation that being brought up in the decision, we will see both violations, 6016B and 6016C. So 6016C has nothing to do about disclosure. It's actually says advertising to provide transportation service or advertising transportation service other than by a brokerage is an offer to provide advertising service. So there is nothing about the disclosure. Disclosure is the 6016B, obviously, and the clarification of 6016B is in 6016B. And when the unlocation presented the Exhibit 205 and the disclosure being made, Chief LJA found it a good faith effort to attempt achieve a compliance, but not more than that. He didn't actually state that yes, unlocation now in compliance, but back in the days when complaint was filed, it wasn't. So, and that's the issue, and we need to cease and desist. No, he just used it as a mitigation factor for not assigning the fines and penalties, but he did not state that in compliance after that. So, and for example, if the evidentiary hearing will be limited to that fact only, we're gonna come back to that original point where the unlocation states in paragraph 120 that it was just a good faith effort attempting to achieve compliance. So unlocation will stay at that stage, at that step. So it didn't go any further. It did not comply with all the rules as ordered, all the rules and statutes, because the chief LJ still made that ruling after SADE disclaimer. So quick history about
so let me just interrupt, Mr. Lysenko. You referenced Exhibit 205, which presumably was in Chief ALJ Adams' proceeding. And based on what you said, my understanding of Exhibit 205 is that it was probably screenshots of On Location's website as of the time, you know, on the day or the day before the hearing took place in Chief ALJ Adams' proceeding. Do I have that right?
Yes, Your Honor.
Okay, sorry, I interrupted. Go ahead.
And that exhibit showed that unlocation already had the disclaimer listed, but the LJA still found it only a good effort to attempt to achieve compliance, because obviously there is much broader issue being raised in that decision, which is obviously 6016C, which left outside kind of. And going back for a quick history, unlocation filed motion to limit the scope on October 24. Motion was about limiting to unlocation advertising, not narrow, not much more narrative. Then I filed 3 days later, I filed the response, arguing on such a broad, actually, I didn't argue much about that because it's kind of true that the problem is in unlocation advertising, it is true. So I didn't argue much about that since it was broader scope of the hearing. So I filed my response on October 27th. Then at the hearing, Your Honor actually stated at the video minute 36:30. And by the way, I have it in my exhibit folder as exhibit 131. And I would like to offer it into evidence with this motion to dismiss the video from the past hearing. So I will offer it at the end. So at the minute 63, at the minute 36 and 30 seconds, Your Honor confirmed with Mr. Jennings that the motion is about advertising in general. At the minute 39:30, Mr. Jennings agreed that it's about advertising in general. And then at the minute 54:30, Your Honor stated that evidence needs to focus whether on location compliant with the Chief ALJ's order, and whether on which ordering on location to comply with rules and statutes governing of its advertising. So not narrowly with the focusing on the disclosure. But then at the minute 58:40, 4 minutes later, when you repeated, and that was, I'm not sure if it was my fault to miss kind of, I did argue it after your ruling, and maybe that's somehow when the proceeding turned the wrong way, but I will try to do better in the future. But at the minute 58:40, 4 minutes later, the ruling went much more narrative, just exclusively whether on location adequately disclose the broker status, and nothing happens within those 4 minutes. It just jumped much more narrowly,
Okay, I think I understand. If you have any other arguments, go ahead.
Yes, I do, Your Honor. So first of all, ruling unsupported by motion. Secondary, it prejudices the complaint because I didn't get the chance to complain on such to argue on such a narrative. So the issue right here with this ruling, whether both parties had a chance to argue on such a narrative topic, limiting to such a narrative topic evidentiary hearing. So then the prior decisions are broader. So to read the decision correctly, we had actually, it was unusual proceeding. We had 2 hearings in the previous proceeding. So it was limited hearing where the complainant is supposed to make prima facie showing. And then we had the full evidentiary hearing. So most of the stuff been already shown at the limited hearing, and the prima facie showings included in term decision, and those as prima facie showings and arguments and facts carried forward to the recommended decision. But in the recommended decision, there was so many motions filed right before, so the LJ focused on some of the motions up there and obviously kicked out the kind of main problem to pretty much the bottom of the decision. And so he's been focusing on several things, and he's been focusing on the location didn't disclose at the time when the complaint was filed, disclosing adequately that they being a broker, but it's only for the reason because on location presented the exhibit 205. So, but after he went through the exhibit 205, he still said that it's just a good faith attempt, and it's actually on location still need to cease and desist until it complies with all, because there is a trace of 2 violations, 6016 B and 6016C, going through the both decisions. And I would like to present that those evidence right now. So if Your Honor and Mr. Jennings, can you please open the decision, interim decision and the recommended decision, please, so we can be on the same page with everyone.
Well, let me ask Mr. Lysenko. I mean, I think I know, we went through a little bit ago what you're looking for specifically. So, what I understand is, you know, you are not disputing that the evidentiary hearing here will be limited to on locations advertising. I think you ultimately said advertising on its website. The evidence will be limited to evidence that has happened, events that have happened since Chief ALJ Adams' decision issued. The thing that you want changed is, well, you want to focus more broadly on locations advertising and not just solely to its disclosure as a transportation broker. That's what you want changed. Is that right?
Yes, Your Honor. And yes, would you like me to present the evidence about broader evidence showing that the decisions are broader than just the issue we limit them to?
So what you want to show me is information from Chief ALJ Adams' interim decision and recommended decision supporting your argument that this should not be narrowed to just focusing on whether on location has in its advertising has adequately disclosed that it's merely a transportation broker. That's what you want to show me?
Yes, Your Honor.
I'm trying to get things moving here. So what I'd like to do is ask Mr. Jennings, before you do that, Mr. Lysenko, what his position is on specifically what you're asking for. So, Mr. Jennings,
Thank you, Your Honor.
we've covered it now twice in terms of what Mr. Lysenko is looking for in terms of modification of what he perceived my previous decision to be, granting in part and denying in part your motion to limit. So what's your position on what he's asking for?
So he's made a motion for reconsideration of your Honor's prior oral ruling?
Yes, and just as I just disclosed, his and the relief that he's specifically seeking.
Okay.
You understand what he's specifically seeking?
I do, Your Honor.
Okay.
So On Location opposes Mr. Lysenko's motion to reconsider your Honor's decision. On Location did file a written motion to limit scope of hearing. It provided citations as to what evidence is relevant, what evidence is admissible. Mr. Lysenko had the opportunity, like any litigant, to file a response to that motion. He did so. He put forth his arguments. So that motion was fully briefed.
Okay, Mr. Jennings, I'm sorry to interrupt. I understand. I was thinking that there was a possibility that maybe your answer would be different to my narrow question. So I'm going to go back and let Mr. Lysenko make his argument as succinctly as possible. Then I'll give you the opportunity, Mr. Jennings, to respond within reason and full. So I was just trying to be efficient here in case you were going to agree to what he was seeking. So Mr. Lysenko, go ahead. Make your argument. Make your argument, please.
Yes, Your Honor. Thank you so much. So the trace of violation, and I will focus on 6016C, which is kind of different from the 6016B, which did knock out pretty much with the Exhibit 205 already. So, but 6016C, the trace of that violation goes through both decisions. So all the way from finding of facts, then legal standards, to the discussions and conclusions, and pretty much through the both proceedings. So first, 6016C, in term decision, if we can open up paragraph 36, it says on location sells individual tickets, the facts. So the next fact, the on location as a customer engages Ramblin' Express to provide intrastate transportation for those individuals. So then later on, moving forward to 47, charter orders show at least 10 instances where Ace Express and Ramblin' Express each were hired to pick up passengers at on locations, pickup sites, and drop off at Red Rocks and Key Theater, and then pick up passengers from Red Rocks and drop them off at on location sites. So this is just a facts, but showing that the on location is in violation of 6016C, which is not advertising by brokerage. So it's not advertising actually on Ace Charter Services. It's actually ordering service. So moving forward, the paragraph 82 actually. And I will go briefly on facts, but I will go much deeply into the discussions and conclusions. So paragraph 82.
Your Honor, may I interrupt? Is he making a motion to reconsider? What precisely is this narrative argument about his position?
He's making a motion for reconsideration. So I'm going to let him continue. Go ahead, Mr. Lysenko. So are you in the interim decision, Mr. Lysenko?
Interim decision, legal standards portion, paragraph 82.
Okay, so why don't you move on to the recommended decision? I understand your point that Chief ALJ Adams stated that he was, hold on. In his recommended decision, he incorporated relevant findings of facts from the limited hearing to resolve disputed jurisdictional facts. So I understand that's your predicate for going through the interim decision. I'm familiar with the interim decision, but I'd like you to focus more on the recommended decision.
Sure, Your Honor, I will skip all of them. Can I just show only one last main one at the interim decision, which was transferred, which wasn't correctly transferred. But the paragraph 97 at the interim decision specifically says Rule 6106C states explicitly that advertising to provide transportation service or advertising transportation service other than by a brokerage is an offer to provide advertised service. And he, in parentheses added, he specifically highlighted in italic the second portion of it where it says other than by a brokerage is an offer to provide advertised service. And later on, he stated that on location is because on location is advertising to provide transportation service and advertising transportation services without disclosing the fact. So this is, he states both rules, offering to provide transportation, which comes from 6016C, and advertising without notifying being a broker, which is 6016B. He found it in violation of those rules. So he actually stated both, and he took those both forward to the recommended decision. Even though he explicit more the first one, 6016B, not notifying, but the 6016C violation, it didn't go anywhere. It's still there. And moving forward, I would like to show the recommended decision. And I'm not going to go through finding of facts which being transferred and discussions. I will just go to the mainly portions. Just one second. So if we can just go to the decision, paragraph 92.
I am there.
Okay, just one second. So here, because on location advertised itself as transportation provider and failed to disclose that it would act as a transportation broker, it did in fact offer transportation service at the issue pursue Rule 6016C. So moving to the next one, 107.
I'm there.
Because on location advertised transportation service as their own service and advertising to provide transportation service, because advertising other service is the offer to provide transportation service, which is 6016C, is an offer to provide advertised service. And he just add number 81, which when we click 81, it takes to the Rule 6016C in the footer again. So I can even show a few more where he specifically discussing the federal authority, and he specifically stated that the on location actually been advertising other service, not the charter bus service. That's why the federal regulations does not apply to them. And that's again another proof that they advertise a different service, not the service actually being provided. And that's another proof of 6016C. So there are several points to 6016C in violation. And when the on location presented Exhibit 205, I understand that LJ went through the proceeding, went through the exhibit, and he actually stated it's a good faith attempt to achieve compliance. But he still, even Judge Rosenberg, she did went through the same conclusion, and in her decision, because her responded actually heavily relies on that decision. And she actually made a note about on location being found only a good faith attempt to achieve compliance, not the actual compliance. So the LJ never said that it's now it's achieved the compliance, but it didn't before. So now it's we still need to cease and desist. No, the cease and desist order and to compliance with all regulations and statutes came with the problem with 6016C left behind, which on location never addressed. And that's why Chief LJ actually noted that the issue being presented incorrectly, because on location presented the exhibit, but they didn't present the issue that they started actually advertising by the brokerage. They started advertising actually as a broker, not just a disclaimer, because the problem is not only in the disclaimer. So he took it as a actually mitigation kind of reason or mitigation point not to assign penalties, but he never actually said that in compliance. So if we're going to narrow it right now, whether on location properly disclosed at the time, we're going to go back to the stage where LJ said that it's a good faith attempt. It's never been found in compliance with the rules, and which is
okay. I think I understand, Mr. Lysenko. So, I mean, what you're seeking is to, again, you agree that this will be restricted. This hearing will be restricted to evidence regarding on locations advertising on its website, and that the evidence will be limited to anything that's occurred since Chief ALJ Adams' decision. What you want to eliminate is your perception that the previous ruling was that the evidence would be further limited, not just to advertising, but to advertising relating to whether on location adequately disclosed that it's merely a transportation broker and does not does not offer the transportation services itself. That's what I understand that you're asking for. So with that, let me turn to Mr. Jennings. Mr. Jennings, you can respond.
Thank you, Your Honor. Mr. Lysenko's motion for reconsideration should be denied. Your Honor issued that oral ruling roughly a month ago, so the parties have been preparing for today's hearing with that in mind. I didn't mean to rehash the whole sort of pleading history, but I think it is important to note just that we filed our motion. Mr. Lysenko had his opportunity, like any litigant, to file his arguments about why our motion should not be granted or other relief that he sought. Your Honor issued a ruling at the prior hearing. Mr. Lysenko's burden to come back this morning and try to reconsider is high. It's not just that he disagreed with Your Honor's ruling. It sounds like he takes issue with some rulings Your Honor made. It sounds like he may take issue with some relief or other way that Chief Judge Adams described certain things in his decision. As to Chief Judge Adams' decision, that ship has sailed quite a long time ago. Mr. Lysenko did not appeal that decision. On Location, for its part, reviewed that decision closely and updated its advertising accordingly. But back to today's proceeding, Your Honor, we believe that the motion should be denied because Mr. Lysenko has not shown that there's been a clear error of law or an injustice with Your Honor's ruling. And some of this gets into the defenses of On Location. So it's clear that On Location and Mr. Lysenko interpret Judge Adams' decision differently. And that just gets to the merits of this case. And Mr. Lysenko is free to make his arguments. Just to respond to a couple things, because Mr. Lysenko is pointing to specific paragraphs. Paragraph 71 of Judge Adams' decision says, at the time the complaint was filed, and this is Mr. Lysenko's original May 24 complaint, On Location did not disclose that it does not own or operate the shuttles. Paragraph 72, since the filing of the complaint, On Location has updated its website. Paragraph 92, going back to the original filing, On Location failed to disclose that it would act as a transportation broker. And paragraph 94 is, there are several sort of key findings that Judge Adams made. But this paragraph says, the advertisement appearing on On Location's website at the time the complaint was filed violates rules 6016 and 6202.
Which paragraph was that?
Your Honor, that is paragraph 94.
So let me ask you this, Mr. Jennings. Do you have a firm grasp on what evidence Mr. Lysenko wants to get in that he believes is prohibited by my previous ruling?
Not well.
I'll be frank. I do not. So that's why I ask you.
No, I do not, Your Honor, but I do think just in the nature of responding to Mr. Lysenko, what he does want to do, in our view, is relitigate the prior case. And he wants to make arguments. He wants to bring claims that were already decided by Judge Adams. And if Mr. Lysenko disagreed with the Chief Judge findings, if he wanted different relief to be issued, he was represented by counsel. We all went through about a 12-month, pretty full hearing proceeding. And that's my sense of what Mr. Lysenko is asking for. So when he says he wants to talk about other issues beyond advertising, he's attempting to reopen the prior case.
So as I understand it, Mr. Jennings, I'm sorry to interrupt, but I've restated I think twice now what I understand Mr. Lysenko agrees with my previous ruling, and one of those is limitation to evidence regarding advertising. That it's not going to go broader than that. That's part of why I don't have a firm grasp on what additional evidence he's seeking to get in through his motion for reconsideration that he believes he cannot get in. currently. I understand your position, Mr. Jennings. Again, I'm trying to be efficient here. Let me turn back to Mr. Lysenko and just ask really briefly, Mr. Lysenko, can you summarize the evidence that you want to get into the record here that you believe is barred by my previous ruling? And you're muted, Mr. Lysenko. Mr. Lysenko, you're muted.
Thank you, Your Honor.
Thank you.
Overall, I would like to present evidence on allocation advertising, which state still in violation of the LJA's order, which says governing its operation, all statutes and regulations, which really is 6016A, B, C, and 6202A, which was noted in the previous decision, not beyond that. It was already noted and it's already been there in the previous decision. And that's what I want to go for. I don't want to narrow it to only 6016B, which says, which is violation of 6016B. So their previous decisions were broader. So, and the issue was broader. And I'm just going for advertising. The broker can only break the mostly advertising rules because the broker is advertising pretty much heavily against the PUC rules. So, and
Okay.
I'm just gonna present the advertisement on the case.
So I still don't have a really clear view of what you want to present. Here's what I'm going to do. I'm going to provisionally grant your motion for reconsideration. The bottom line, Mr. Lysenko, is we're not going to take evidence that was taken previously. And in the previous proceeding, Chief ALJ Adams proceeding, and we're not going to relitigate issues that were raised or could have been raised in Chief ALJ Adams' proceeding. With that, I'm going to provisionally grant your motion for reconsideration, and I will consider objections to the evidence as it comes in about whether you're going too far or not. So with that, is there anything further that anybody would like me to consider before we get going with the evidence?
Yes, Your Honor.
Go ahead, Mr. Valentine.
Given that Your Honor has limited this case to advertising, and I believe it's still about what's on Location's website, I would request again that my witnesses be excused. They have no personal knowledge of what's on the website or any knowledge of decisions made with regards to On Location's advertising. We will stipulate right now that we provide charter bus service to On Location and that nothing has changed since the prior proceeding.
So I'm going to deny your motion / request. Let's just hear that from your witness or witnesses, and it will be very brief testimony. If the testimony is consistent with what you just said, Mr. Valentine. So
Thank you, Your Honor.
I know your witnesses have been, forced to testify and address basically this relationship on multiple prior occasions. They're already here. Let's just get the evidence in and
understood, Your Honor. And if Mr. Lysenko doesn't mind, I would ask that they go first.
So okay, I understand. So go first in his case.
Yes.
He's the one who subpoenaed them, right?
That's correct.
Okay, Mr. Lysenko, are you let me ask you, are you willing to accommodate that request that they go first so that they can move on today with their lives?
Definitely, Your Honor, and I want to ask Mark Valentine if I still need to call Mr. Holland first, or if he needs to go and come back like in 30 minutes or 40 minutes and kind of Because I've heard that he had something scheduled for 10 a.m.
Yes, let's get Mr. Holland on first, please. I appreciate that, Mr. Lysenko.
Okay, Mr. Holland, if you have the capability to turn on your video and unmute yourself, that would be appreciated.
Yes.
Good morning, Mr. Holland, and thank you for being here. And before we go further, let me ask you to raise your hand and answer the following question. Do you swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Great. Thank you, Mr. Holland. Mr. Lysenko, you may proceed.
Thank
Oh,
you,
well,
Your Honor.
first, let me just ask you, Mr. Holland, just state your name for the record and
Sure.
spell it as well.
Yeah, good morning. My name is Todd Holland, T-O-D-D-H-O-L-L-A-N-D. I'm the president and owner of Ramblin' Express Incorporated here in Colorado.
Thank you very much. Mr. Lysenko, go ahead.
Thank you, Your Honor. Mr. Holland, hello. So you already stated your name for the record. Are you currently employed? I just want to lay proper foundation and then I'll move on. It's going to be quick. Are you currently employed?
Yes.
Who do you work for?
Ramblin' Express Incorporated.
What is your position within the company?
President.
Do you represent Ramblin' Express today?
Yes.
What service does Ramblin' provide?
We provide shuttle, charter, and fleet maintenance services.
Do you know on location the respondent in this case?
Do I know them?
Yes.
I do.
Okay. How do you know them?
On Location is a charter client of ours.
Got it. Do you so does the Ramblin' Express still provide services to On Location?
We do provide charter services on location.
Got it. Do you remember the previous proceeding where Ace, Ramblin', On Location, and Mountain Star were involved?
I do remember that.
Do you remember when and how it ended?
I don't remember the details and specifics of that.
Got it. It's actually the final decision was on May 29th. So all my questions going further gonna be from May 29th. I will keep repeating that, but just in case if I forget, from May 29th, since May 29th, keep in mind that it's from May 29, 2025. So who's your main contact at On Location?
I'm not sure. There are various people at let me back up. My charter salespeople probably communicate with various people at On Location. I'm not sure who that primary contact has been.
Is the Rick Van Patten still the person contacting you since May 2029?
My understanding is that Rick Van Patten was that point of contact for a period of time until he left On Location.
Got it, but not anymore. Am I correct?
My understanding is he's not with On Location now.
Got it. Did Ramblin' Express make any changes working with On Location since May 29, 2025?
We didn't make any changes to the relationship or the operations between our companies. There may have been changes to the actual charter pricing year over year.
Makes sense. Since May 29 of this year, has Ramblin' Express asked On Location to advertise Ramblin' service?
I don't believe so.
If after May 29, 2025, On Location continued to advertise transportation service, is it Ramblin' service that On Location advertises?
Objection Foundation.
Sustained.
Could you repeat the question, Rowan?
You said to repeat the question?
Yes, please.
I think
Yes,
he's
could you
gonna ask
repeat
I
that
think he's going
question?
to ask a new question.
Yes. So I cannot go back. I will ask next question. The objection was sustained. So
Thank you.
Since May 29, 2025, has Ramblin' Express give permission to on location to advertise its own service?
I don't understand the question.
So
On location charters buses from us, so they're not advertising our service.
they not. Okay. So and if on location sells or advertises per seat tickets, they not yours. Am I correct?
We do not sell tickets for the services that they provide.
And do you have any involvement in on locations advertisement?
No,
Like not even. Okay.
do not.
Not even description of the service, the price for the advertised service, or like times that the service advertised for. Am I correct?
You are correct. We do not have any involvement in that.
Since May 29, 2025, have you ever discussed with On Location to list Ramblin' Express on their website or anywhere else on location advertisements? Well, On Location website.
I do not believe we have, no.
But thank you, Your Honor. That's all my questions.
Thank you, Mr. Lysenko. Mr. Jennings, do you have any questions for this witness?
No, thank you, Your Honor.
Okay, and I don't have any questions for you either, Mr. Holland. Thank you very much for being here. Appreciate it. And you're excused now.
Thank you.
So, Mr. Valentine, I take it you'd like your other witness to go now if Mr. Lysenko will agree, or if I'll impose it.
Yes, Your Honor, I agree totally.
Okay, great. So, Mr. Lysenko, you may call your next witness formally, please.
And I would like to call Mr. Davis, the next witness, Ace Express coaches. Hello, Mr.
One moment, Mr. Lysenko. Thank you. Mr. Davis, welcome. Thank you for being here. Please raise your hand and answer the following question. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much. Please state your name for the record and spell it as well.
Yeah, my name is Sean Davis, ShawnDavis.
Thank you very much, Mr. Davis. Mr. Lysenko, you may proceed.
Thank you, Your Honor. Hello, Mr. Davis. I'll move forward. Are you currently employed?
Yes, I am.
Who do you work for?
My current role is with All Aboard America Holdings Incorporated. That's the parent company that owns Ace Express LLC.
Got it. Do you represent Ace Express coaches today at this hearing?
Yes, I do.
What services does Ace coaches provide?
A variety of transportation services that include charter bus, public transportation, and employee shuttle.
Got it. Do you know On Location Events LLC, which is responded in this case?
Yes, I do.
How do you know On Location Events?
They're a customer of Ace Express coaches.
Does Ace still provide service to On Location?
Yes, they do.
Do you remember the previous proceeding where Ace, Ramblin' On Location, and Mountain Star were involved?
Yes.
Do you remember when and how it ended?
Yes, I saw the ruling. I couldn't explain the details. I was brought in as a witness.
Got it. So again, I will be asking all the questions since May 29, 2025. So if I forget to add scenes from That's the date we're talking about. Who is your main contact at on location?
It's changed over the years. Most previously, it was Rick Patton. Rick Patton is no longer employed at On Location. So there's a new contact. I believe his name's Michael or Mike.
Thank you, Mr. Davis. Did ACE make any changes to operations working with On Location since May 29?
No material changes. There may have been a price adjustment. This is typical once a year.
Since May 29, 2025, has ACE asked On Location to advertise ACE's service?
No, we have not made that request.
Since May 29 of 2025, has ACE paid a commission to On Location for advertisement of ACE
No.
services?
No.
If after May, highly potentially, May 29, 2025, On Location continued to advertise transportation service, is that ACE's service that On Location advertises?
You broke up a little bit. Can you repeat that, please?
Yes. If after May 29, On Location continued to advertise transportation service, is it ACE's service that On Location advertises?
Objection, Foundation.
Sustained.
Since May 29, 2025, has ACE given permission to On Location to advertise ACE's service?
No.
Since May 29 of this year, if On Location advertises individual seat tickets, are those tickets ACE's?
Objection, Foundation.
Sustained.
Do I get the chance to respond
Go ahead, Mr. Lysenko.
to objection? It's a highly just hypothetical question about the if On Location sells the tickets, if it's ACE's tickets. ACE doesn't need to know about does it sell it or not. It's just the personal knowledge of Mr. Davis.
Well, the way the question is phrased, there is inadequate foundation for the question. That's why I sustained it, and I'm going to stick with sustaining it.
Thank you. And next question. Does ACE ever ask since May 29th On Location to sell its own individual seat tickets?
No.
Has ACE had any involvement in On Location's advertising?
No.
And just to clarify, like with Mr. Todd, not even description, pricing, not the times for the service advertised, nothing like that. Am I correct?
You're correct.
Since May 29th, have you ever discussed with On Location to list ACE on their website?
Just for clarity, the question is, have I discussed the involvement of Ace Express or text about Ace Express on their website?
Let me repeat the question. Since May 29, 2025, have you ever discussed with On Location about listing ACE's information on their website, on Location's website?
No, sir.
Thank you, Your Honor. That's all my questions.
Thank you, Mr. Lysenko. Mr. Jennings?
Just a few questions, Your Honor. Mr. Davis, you testified that you were involved in the prior proceeding, which was the complaint filed by Mr. Lysenko, his company, against On Location, Ace and Rambling. Is that correct?
Yes, I think there's been a lot of those calls, so I don't fully know the specific one he's referring to, but I've testified several times now.
Okay. And one of those was a case involving On Location. Is that right?
Yes.
Okay. Mr. Lysenko's asked a couple times about actions that your company took or did not take after May 29th of this year. Do you recall that?
Yes.
And I'm going to assume that because you didn't take any actions, you didn't believe that any compliance actions were required to be taken as a result of the prior complaint case. Is that right?
I think the way, let me understand that.
Objection, Your Honor. It's a leading question. The attorney leads the the witness.
I'm going to overrule. Go ahead, Mr. Davis.
When I think the final ruling came out, there was no actions required for Ace Express or any other charter bus company. So I didn't have to take or didn't view any sort of changes in the business as necessary. Is that, I think, answering the question?
Yes. And so is that why? Yeah. And so am I correct that you did not take those actions after you considered the PUC's prior order in the first case?
That's correct.
Okay. And do you recall that Ace and Rambling were dismissed from the prior case with On Location?
That's correct.
And you may not remember all the specifics, but I'm looking at paragraph 118, which states that the transportation provided was not unlawful. Do you remember that?
Very clearly.
Thank you. No further questions.
Thank you, Mr. Jennings. Mr. Lysenko, do you have any redirect addressing anything Mr. Jennings just asked about?
No, Your Honor.
Okay, thank you. Mr. Davis, I don't have any questions for you either. So let me thank you again for being here today and participating in this hearing. I know you have testified on several occasions previously. The commission very much appreciates it. So with that,
yeah, thank you. I do want to say one thing, I want to apologize for November 18th. I was flying internationally and that was the 19th for me and I got very screwed up by that. So apologies for missing the last one. That was, unprofessional and I just want to say that.
thank you very much for that. I appreciate it. So with that, you are excused.
Thank you.
Mr. Lysenko, you may call your next witness.
Judge, may I be excused for the rest of the hearing?
You don't want to stay?
I will be checking in, but not on this website.
Okay, you are excused, Mr. Valentine.
Thank you, Your Honor.
Thank you. Mr. Lysenko, are you the next witness?
No, Your Honor. Mr. Bott will be the next witness.
Okay. How long do you anticipate? Well, let's just do this. It's at 10:20. Let's take our mid-morning break now. Well, let me just ask, does Mr. Butt, if I'm pronouncing that correctly, have anywhere to be anytime soon?
I do not. It's bot I, but I do not. I can take all the time for you guys.
Okay, thank you. So it's Badai, you said?
Yeah. That's if there's an I instead of an E on the end of it. I've gotten it.
Okay.
I've gotten it always through my life.
I'm sure. And I'm sure you also say, Batai, and then you just start into BOTTI or E.
You said it.
Yeah. Okay. Let's take our mid-morning break until let's say 10:40. So we'll be in recess until 10:40. Thank you.
Thank you.
All right, I see everybody back. Miss Boulay, are you ready to go?
I am ready.
And Miss Crane?
I'm ready.
Okay, we're back on the record in proceeding number 25F-0270CP. Mr. Lysenko, you may call your next witness.
Thank you, Your Honor. I would like to call my next witness, Mr. Bataille.
Thank you very much. And Mr. Badai, thank you for being here. And please raise your hand and answer the following question. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Great,
Yes.
thank you. Please state your name and then spell it for the record.
Michael Bodai, Michaelbotte.
Thank you. Mr. Lysenko, you may proceed.
Thank you, Your Honor. Mr. Bataille, are you currently employed?
Yes.
Who do you work for?
On Location, LLC.
What is your current position with the company?
Vice President, Business Operations, Class Festival Services.
Okay. Do you represent On Location today?
I do.
What services does On Location provide?
On Location provides hospitality, travel, and transportation services in the music and sports industries.
Got it. Does On Location events still operate Shuttles to Red Rocks program?
Yes, we do.
Does On Location events still owns rrxshuttles.com?
Yes, we do.
Who manages the Shuttles to Red Rocks program?
We have a local team that's in Denver, led by Michael Moore, that oversees that program. I currently oversee that office that is in Denver.
Okay, you oversee them. Okay. And who do you report to?
I report into our executive leadership team at On Location.
Got it. Ms. Crane, would you mind, can you please pull up Exhibit 104? Mr. Bataille, do you recognize Exhibit 104?
I do.
What is it?
This is a website for Shuttles to Red Rocks.
Got it. Is it rrxshuttles.com we spoke before?
Correct.
Got it. When is the last update was made, except for adding up new concerts? When does the last update was made to the website?
I am not sure on the last update. We make updates current throughout the cycle of our business. I know there have been updates made throughout the summer.
Okay, got it. Can we just scroll down, please, the screen to page 2? Just right here, I apologize, at the bottom of number 1, right here. So On Location added this disclaimer, and I believe it was added in the previous decision. Did it stay the whole time on the website?
Yes, this stayed on the whole time and is currently on our website.
Got it. All right. What's the purpose of this website? What does it do?
This website sells shuttle passes to Red Rocks, which is a service we provide to prevent safe ways for guests to get from downtown Denver to the Red Rocks music events throughout the year.
So that's On Location still advertises and sell shuttle tickets to Red Rocks,
We do.
even like today's date, right?
Today's date. Yeah.
Got it. Since May 29, 2025, did it stop for at least a day, or it's been always up and running?
We've always been up and running. Yes, we've always been selling tickets, and we've updated our language as appropriate throughout the year.
Got it. The program name, the website, the main name, the website logo, then in the website contest, you guys use lots of times word shuttle, several times word shuttle, like RRX shuttles, shuttles to Red Rocks, plus in the content everywhere. Is it the service you guys advertise on this website?
Shuttles?
Yes.
Shuttle transportation? Correct.
Got it. And since May 29th, has RRX Shuttles always been a public website? It's always been available to public?
Yes.
Got it. And just to clarify, that means anybody can just go and just buy the ticket. Am I correct? So it's unrestricted. Got it.
Was that correct, Mr. Bhatai?
Yes, correct. Sorry. Yes,
Okay.
he is correct.
Thank you.
And does On Location still orders shuttle buses from East and Ramblin' Express to
Yes, we do.
transport? Got it. After May 29th, is On Location still the one who determines for the services being advertised, the advertised service pickup time, pricing, description for the service it advertises? Am I
Yes.
correct? Okay.
Yes, we are.
And can we please zoom in the disclaimer, Ms. Crane, please, so we can just read it. Thank you so much. It's at the bottom of page 1. Yep, right here. So I will read through really quickly this disclaimer. On Location is a transportation broker that arranges your round-trip transportation with local third-party transportation providers that operate pursuant to applicable permits and laws, such as third-party providers own and operate the vehicles that they will transport you to the destination. If you have any questions or concerns regarding your transportation experience, please contact us, and we will promptly contact local transportation partner. Do I read it correctly? According to this statement, does the customer need to contact you if something happens, if there is a problem with transportation?
There's a problem with their experience that they purchased on this website, they will contact us.
Got it. And what do you do then?
We'll, if it has anything to do with the bus or provided or with the transportation provider, we will work with them to provide an applicable solution and make sure it doesn't happen again.
Got it. Makes sense.
That's you know, in the 10 years we've done that, I don't know of any of that occurrence ever happening.
Mm-hmm.
So, Mr. Bhatai, in your answer, you referenced them. We will work with them. I take it that you mean the local transportation partners?
Correct. The ACE and Rambling relationships that we have in that market. Yes.
Thank you. Go ahead, Mr. Lysenko.
Okay. At May 29th, on May 29th, 2025, what steps did on location took to ensure compliance with the decision and cease and desist order?
We updated this language that you're looking at right here. We had originally had this language on our website prior to that decision, stating that we work with 3 third-party vendors, but we added the language that we are a transportation broker. And there was also a logo on this website that had a bus that had the logo of the program on it, which we approved to remove from this website. So those were the two main changes. And this language that you see here is replicable in other areas of the website.
Thank you. And did on-location events reach out to PUC to check, to confirm that the changes been effectively, that they did on-location reach out to PUC to check what needs to be done?
I do not know.
Okay. Did you contact them after you make the changes to make sure it's in compliance before you start operating?
I do not know.
And
You
Mr.
don't know?
Lysenko, you just used the word them as well. I take it you were referring to the commission, the Public Utilities Commission?
Yes, Your Honor.
Okay, thank you.
And Mr. Batai, you personally didn't contact, am I correct?
I personally have not contacted, no.
Okay. Who would have contacted in case if you guys need to contact PUC?
Objection, speculation.
I'm going to overrule and allow the answer.
The team that we have in place to run that program. I have a full operational team that runs our Red Rocks to Shuttles program in Colorado that is in charge of this business.
Got it. Did they report to you by chance saying that they contacted or not, or any information about that?
They did report back to me on the changes that were made to the website.
Okay, got it. Did you hear testimony from ACE and Ramblin representatives today?
I did. Yes.
Okay. Did you hear Mr. Davis saying that ACE didn't ask on location to advertise their services?
Yes, I did.
Okay. Did you hear Mr. Holland saying that Ramblin didn't ask advertise their services?
Yes.
And did you hear them saying that they have no control, nothing to do with advertisement? Am I correct?
Correct.
So whose shuttle tickets or passes do you advertise on this website?
On locations.
Your passes. Okay. Did on-location events obtain a certificate from PUC to advertise on passes?
Objection, Your Honor. This matter was extensively covered in the prior case with respect to the permits and certificates. And then also, Your Honor, the prior decision.
I'm going to sustain it. I mean, Mr. Badai, you don't have any or your company on location doesn't have any relevant authority. I mean, no authority obtained from the Public Utilities Commission. Is that right?
Not to my knowledge, no.
Okay, thank you. Mr. Lysenko, go ahead.
Thank you, Your Honor. I was trying to rephrase my question to that question. So I guess I need to move over. But just to confirm, since May 29th, you have not applied, you have not received the authority from the PUC. Am I correct?
Not to my knowledge.
Okay. All right. And Ms. Crane, I will be offering these exhibits through my testimony, so we're not going to offer them right now. But Ms. Crane, could you pull up Exhibit 110? Please. Okay. Mr. Batai, do you recognize this exhibit?
I'm not familiar with this exact page, but it does look like a purchase page for the shuttle pass.
Got it. Does it look like maybe the actual ticket which get an email to people?
Yeah. Yes.
Okay. Who and Ms. Crane, can we scroll down, please? That's right here. We can leave it right here. So who issues this ticket?
Our ticketing partner, C-Tickets.
C-Tickets. So they process, but whose ticket is that?
Can you rephrase the question? I mean, like, what do you mean whose ticket? Well, ultimately, it would be the guest's ticket.
The guest ticket, yes, but what company issued this ticket? So when somebody purchased the ticket, who issued this ticket?
Objection, Your Honor. Objection. So I'm going to point to paragraph, and this is just in the nature of this stuff was already covered and should not be duplicative and entered again. So paragraph 55 of Judge Adams' decision says, On Location sells individual tickets through its website, rxxshuttles.com. Paragraph 58 says, when a member of the public purchases a ticket from On Location, the ticket is delivered to the purchaser via email, shows the date of transportation, the time of concert, the point of origin, and a map showing the destination. So this looks like potentially a different version of something that was already covered by Judge Adams' decision.
Okay, thank you. I'm going to overrule. You can go ahead and answer, Mr. Badai. Mr. Lysenko, this is plowing ground that's already been plowed in Chief ALJ Adams' proceeding, but I'm going to allow you to proceed to see where you want to go with this. Go ahead, Mr. Badai. Do you remember the question?
Yes. Can you please repeat the question?
Yes. Who issues this ticket? Whose ticket is that?
This ticket is sold on the On Location website and issued via our ticket partner via this what we're looking at right now to the guest.
Okay. And the ticket partner, you mean the software which your admin software to control individual sales, am I correct?
Correct.
Got it. And in the previous decision, it was stated several times the definition of the partner. So the partner offers to arrange transportation service under somebody else's authority. So under what authority do you guys, if you know, you guys offer or advertise this service?
Objection. Calls for legal conclusion. Authority has a specific meaning, and this is a fact witness that's here to talk about On Location's advertising.
I understand. I'm going to overrule and allow the witness to answer.
I'm not sure I understand the question.
So I'll repeat and rephrase the question. Usually, a broker operates under somebody else's service, like somebody else's certificate. They resell somebody else's service. So my question is, under what authority or whose authority do you advertise individual tickets on your website?
I'm not sure how to answer that question. I would say under our business license. I'm not sure how to answer that.
Got it. Are the shuttle tickets available for 2026 shows for next year right now?
Yes, there are.
Did since May 29, 2025, did On Location discuss advertisement with Ace and Ramblin at all?
We have not.
Since May 2029, have you, okay, it's asked and answered. Okay, if On Location will get another cease and desist order without penalties being assigned, will On Location stop offering and advertising shuttle service?
Objection calls for legal conclusion.
Yeah, I'm going to sustain that.
Okay. I'll rephrase it, Mr. Batai. Do you know if On Location trying to find a legal way to operate its program to Shuttles program to Red Dogs?
Do we aim to operate in a legal way? Of course, we always aim to operate under all legal guidance. Yes.
Okay. And will okay. Well, and once again, in your disclaimer, you mentioned you're gonna you booking with your local transportation service provider. Who are those service providers?
Who are our local service providers?
From your
Ace,
disclaimer.
Express, and Rambling.
Got it. Those two. Is there anywhere on the website that they're listed somewhere?
Not to my knowledge.
Thank you, Your Honor. This is all my questions. Thank you, Mr. Batai.
Thank you, Mr. Lysenko. Mr. Jennings, are you going to call Mr. Badai in your case?
Yes, Your Honor. I don't have any, further questions, but we will call him in our case.
Okay. All right. Thank you. Mr. Badai, I don't have any questions for you. You're not excused. You're going to have to stick around. We'll see you in a little bit. So, Mr. Lysenko, you can call your next witness.
Thank you, Your Honor. I would like to call myself, Roman Lysenko, and I would like to ask you permission to just testify in the natural flow without asking and answering questions, if I may.
And that's fine to conduct your testimony that way. Before you start, please raise your hand and answer the following question. You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Your Honor, may I ask a question before he proceeds?
Okay.
I don't want to interrupt a lot, but if this was done in a question and answer format, we have the opportunity to object. And so On Location just has an interest in making sure that the testimony and the evidence that Mr. Lysenko is going to elicit is relevant and follows the guidelines of Your Honor's ruling. So, I'll just ask your preference. I mean, we would like to make objections to the extent that Mr. Lysenko testifies or tries to introduce evidence that is not relevant and is not admissible.
You can object within reason as the testimony is coming in.
Okay, thank you.
So, thank you. So, Mr. Lysenko, for formality, why don't you introduce yourself and spell your name for the record as well?
Thank you, Your Honor. My name is Roman Lysenko, and my The spelling is Roman, last name Lysenko, and I'm the complainant in this case.
Thank you very much. Just go ahead, Mr. Lysenko.
Thank you, Your Honor. So, Ms. Crane, would you mind, please, can you please pull up Exhibit 104? Thank you. Your Honor, this exhibit I have downloaded and prepared myself. It's never been altered. So this is the on-location website, which is rrxshuttles.com. And obviously covering the time, it was downloaded on October 6th, 25. But I did not notice. I've checked a couple times. I filed the same exhibit with my complaint. Not the same exhibit, but the same page of this exhibit, and I didn't notice any changes. So it's always been pretty much the same. On this exhibit, I did notice that the large bus with logo disappeared, but everything else kind of stayed the same. The logo stayed the same. The disclaimer was pretty much the same. I believe the first two words being added, saying that allocation is transportation broker. And Ms. Crane, could you please scroll down slowly to the...
So, Mr. Lysenko, let me just ask you, so it stayed the same. So are you saying that it stayed the same since October 6th when you printed this? Is that what you're saying?
No, it stayed the same pretty much since May 29th, 2020.
Okay. All right. Got it. Understood. Go ahead.
I actually had the same page filed with the complaint, and it was the same. So
and let me just interrupt one more time. Sorry for clarification. So it's pretty much stayed the same since October 29th. I'm sorry, May 29th, 2025. It sounds like maybe they on locations added the words transportation broker since May 29th, 2025. Is that what you just said?
They actually added it before and
Okay.
presented it in the exhibit 205, but that disclaimer didn't have the first, I believe, 4 words. On location is a transportation broker. Well, 6 words. So they added it, I believe, transportation broker verbiage, but it stayed since exhibit 205 pretty much the same until today's date. So, this exhibit never been altered, and I would like to offer this exhibit into evidence.
Mr. Jennings?
No objection.
104 is admitted.
And Ms. Crane, can you please pull up exhibit 105? All right. And thank you, Ms. Crane. So this exhibit is the shuttle stops. That's additional. It's just a web page on the same website. It was downloaded in October also, but again, it stayed the same from the May 29th, 2025. This is basically showing what's the pickup locations, pickup location for the shuttles. And Ms. Crane, could you scroll down, please? Thank you. So I did downloaded it. I did inspected it. I didn't see any information about any transportation service providers in this one either. And this exhibit never been altered, and I would like to offer this exhibit into evidence.
Any objection?
No objection to the exhibit, Your Honor. I would like to note that this is On Location's website. Mr. Bowtie will get into changes that were made or not made. So we don't agree with everything that Mr. Lysenko is saying to authenticate this, but I don't object to the exhibit.
Okay, it's admitted. 105 is admitted. Go ahead, Mr. Lysenko.
Thank you. Ms. Crane, can you pull up exhibit 106, please? Thank you. And this is the On Location's website. Again, the same rrxshuttles.com. This is the web page which, when you click on buy shuttle passes, that will take you. Ms. Crane, can you please scroll down? And on the right-hand side, we see all the shows that On Location services, and the shows you can purchase a ticket, individual ticket to get there and to come back to Denver. This exhibit never been altered and is prepared and downloaded by me. I'd like to offer this exhibit into evidence.
Any objection, Mr. Jennings?
No, Your Honor. And there is an advisement that was kind of scrolled through quickly, but there's an advisement on page 1.
Yep.
Understood. 106 is admitted.
All right. And Ms. Crane, can you pull up exhibit 107, please? All right. And this is the web page on the same website, which offers the ticket to get to the Conan Gray show. And Ms. Crane, can you scroll down, please? And this is the details about the service being offered. So this exhibit never been altered and has been prepared by me, and I would like to offer it into evidence.
Any objection?
Is this the exhibit that you discussed with Mr. Bowtie, or is this different?
It's different. It's the first page where you choose the concert or show you want to go for.
So I believe the exhibit, he discussed 2 exhibits with Mr. Bowtie. I think the one you're referring to, Mr. Jennings, was 110, which we may or may not be getting to. So this is 107. Any objection?
No objection.
Admitted. 107 is admitted. Go ahead, Mr. Lysenko.
Ms. Crane, can you please pull up exhibit 108? And this exhibit is the confirmation page. It says, thank you for your order. On October 6th, I purchased a shuttle ticket. Obviously, it was one ticket to the Conan Gray show from the Thirsty Lion restaurant in Denver. And this is the confirmation page on the website for this purchase. I've noted the Shuttles to Red Rocks logo on it. And Ms. Crane, can you scroll down, please? Yep. So I didn't notice any information on any of the transportation partners listed right here. And this exhibit never been altered. And I prepared it and downloaded, and I would like to offer this exhibit into evidence.
Any objection?
I'm not sure about the authentication of this, Your Honor. There's a name listed at the top, I think on page 1.
Right. Ms. Crane, could you scroll up, please?
Oh,
So may I inquire about this exhibit?
yes, you may.
That was a question to me, I think.
I'm sorry.
Yes, you may.
All right. Mr. Lysenko, you didn't show this exhibit to Mr. Bowtie, is that right?
I didn't.
Okay. Ooh, it looks like there's a name on here. Sommer Parker. Who is that?
Yes, that's what I used. The name I purchased it, but I used that name because the previous usually from Lysenko they will just cancel the bookings for some reason right away. So I just used that name to book this ticket.
Is that a real person's name?
No, I just made it up.
Okay. So you made up a name to purchase a ticket that you're trying to introduce as an exhibit here today. Is that right?
Well,
I mean, I'll cut to the chase, Your Honor. We object to this exhibit. I mean, obviously it's come to light that there were some interesting tactics that Mr. Lysenko went through to purchase this, but I'll leave it there. We object to the admission of this exhibit.
Okay, I'm going to overrule the objection and admit it. Mr. Lysenko, you can proceed.
Ms. Crane, can you please pull up Exhibit 109? Thank you. And this exhibit is showing confirmation email that been emailed to me. The email russian_services@yahoo.com is my email. And after purchasing the ticket, I received such confirmation. Ms. Crane, can you scroll down, please? So this is the confirmation for the same purchase. And at the bottom, there is a PDF. It says receipt, but it's actually, that's the exhibit 110 we're gonna move forward. This is the kind of actual ticket which is attached to the confirmation email. This exhibit never been altered. It's prepared by me, and I would like to offer this exhibit into evidence.
Any objection?
Objection, Your Honor. Just for the record, the
Same
ticket.
basis as last time?
Well, that one, Your Honor. Additionally, though, this exhibit is issued. I don't see the name On Location on this exhibit at all. The scope of today's hearing is the online advertising of On Location. And that was the nature of the violation that was found in Chief Judge Adams' decision. And that's why Mr. Lysenko brought his second complaint, whether On Location complied with the advertising orders in Judge Adams' decisions. So there's a couple other documents we may get there based on the exhibit list, but a document that has
Are you
no,
saying is your basis that this is outside the scope of this hearing? Is that basically it?
correct, because it's not an advertisement of On Location.
Okay.
It's a third-party company.
Who's a third-party company?
Apparently, this entity called C Tickets.
Okay. I think I understand. I'm going to overrule and admit it. And Mr. Lysenko, you may proceed.
Ms. Crane, can you please pull up Exhibit 110? And thank you. So this is the exhibit we discussed with Mr. Batai, and this is the exhibit. This is the PDF file which is attached to the confirmation email. And in this email, I see words, "This is your ticket," and it gives the shuttle pickup information, and it gives the confirmation number. And Ms. Crane, can we please scroll down? It shows On Location logo. Can we scroll down, please? Oh, this is it. And we didn't, I didn't see any notifications about the service providers, actual service providers. The only logo I see is the shuttle to Red Rocks, and obviously the C tickets, which Mr. Batai testified, the third-party ticket admin panel or ticket partner, which delivers the tickets to customers. This exhibit never been altered. I prepared it, downloaded it, and I would like to offer this exhibit into evidence.
Mr. Jennings, any objection?
Objection on the ground, Your Honor, that this is essentially an identical exhibit and an identical area of testimony that was covered in the prior proceeding and was memorialized in Judge Adams' order.
Okay.
Your Honor,
I'm going to overrule, and I'm going to admit it. Mr. Lysenko, you can continue.
Your Honor, I would like to admit the exhibit 131, which is from the video from the past hearing. Obviously, we don't need to open up. We can open up if we need to that video, but I would like to admit that video from the motion standpoint.
So Mr. Lysenko, are you talking about the video of the hearing on November 18th?
Yes, you're right.
In this proceeding?
Yes.
Okay. I'm not going to admit that. I can consider anything within the administrative record of this proceeding. So it's unnecessary to formally admit it as an exhibit in this hearing.
I got it. Thank you, Your Honor. So before I filed the complaint, obviously I saw the order from the previous LJ, and I did inspect the On Location website, rrxshuttles.com, and I have went through the website. I didn't see any notifications about who the authorized partners are on the website. I went through the purchasing the ticket all the way to the ticket, and I didn't see it being listed anywhere either, not even on the actual ticket. So I did found the disclaimer. According to that disclaimer, our Shuttles and allocation is the broker, transportation broker. But at the end of it, it still says, with any questions and concerns regarding your transportation, please contact us, and we will promptly connect with the local transportation providers or partners. Today, obviously, I represent myself and in my personal capacity, but obviously, I was involved as a company owner in the previous proceeding. And as my personal knowledge, being the owner of transportation company and authorized service provider, on locations advertisement is harmful. So on location advertisement is redirecting traffic from authorized service providers. So by redirecting traffic, we drive in authorized service providers. They drive half-empty buses, and
Objection relevance. So this issue actually was raised in our motion and Mr. Lysenko's response. Market harm, stuff like that is way beyond the scope of today's hearing.
Thank you, Mr. Jennings. I'm going to overrule, but Mr. Lysenko, I'll let you go into this in a very limited way. But you shouldn't go into much detail on this at all.
Thank you, Honor. I just would like to say how harmful, and I'm talking about advertisement, how on locations advertisement is harmful for authorized service providers. And I do understand it's not in the public interest because it drives prices up for authorized service providers because they need to cover their expenses, obviously, and they drive in with the half-empty buses. So another thing, after this, after first proceeding, I've noticed that cease and desist orders without assignment penalties simply don't work. So we have seen at least 2 or 3 other companies start up doing an advertising exactly as on location advertises. So on location advertises gives the wrong message to the public. And with that being said, it just drags the huge problem with the companies advertising as transportation brokers, just following the on location schemes. And
you believe that on locations advertisement complies with Chief Judge Adams' decision?
I do not believe. I believe that they continued providing, and I will save that to my closing argument, or if we're gonna do the brief at the end of it. But I do not agree with that. On location did not comply with the order. And I will address those in my closing argument. The other thing is I calculated 196 days of violation and advertising since May 29th. And,
Objection, Your Honor. Mr. Lysenko is here to testify as a fact witness about facts and evidence. This is not the time for him to talk about his position in the case, which we disagree with. And we can't just...
So I understand, Mr. Jennings. I mean, 196 days is a fact. I'd be interested to hear how he calculated that, but I'm going to overrule and allow Mr. Lysenko to continue.
Got it. And so on location advertisement drags behind several other companies that following advertising, copying, and advertising the same way as on location advertisers. So, and everybody else have the same big excuse. Oh, we didn't know. Oh, we don't know. But they do operate for like, and on location in this case operate for such a long period of time and advertise for such a long period of time, so they make huge harm for the public, for the authorized service providers. And then I see that penalties cases when the cease and desist order issued without penalties, they just simply don't work, and everybody just keep going with the big excuse. Oh, we didn't know, we didn't understand. That's what eyewitnesses and what's the allocations advertisement drugs and prior decision drugs behind. So this is
So basically what you're saying is cease and desist without a penalty. You've seen that doesn't incentivize behavior that you believe it doesn't incentivize behavior that complies with the law. Is basically what you're saying?
Yes, you're right, Your Honor.
Okay. All right. So the 196 days, is that from May 29th through today?
Today, exactly.
Okay. Keep on going, please.
This is it, Your Honor. That's all my testimony, and I'm ready for cross-examination.
Thank you. Mr. Jennings, cross-examination.
Thank you. Good morning, Mr. Lysenko.
Mhm.
We don't need to pull them up, but you introduced a series of exhibits that were on Location's webpage. Do you remember that?
Yes, I do.
Okay. And I believe that was 104, 105, 106, and 107. Do you remember those exhibits?
Yes, I do.
Okay. And on each one of those exhibits, there is a written disclosure that On Location acts as a transportation broker. Is that correct?
Yes, you're correct.
And Mr. Lysenko, you're the owner of Mountain Star Transportation LLC, doing business as Red Rock Shuttle. Is that correct?
Yes, that is correct.
Are you the sole owner of that company?
Yep.
Okay. The prior complaint that we've been talking about, you personally signed that complaint, the first complaint against On Location. Do you remember that?
Yes, I do. Yep.
And in the prior case that we've been talking about, did you act as the representative of Mountain Star Transportation?
Yes. Yep, I did.
And you personally appeared at 2 different hearings in that case, is that right?
That is correct. Yep.
You were a witness for Mountain Star Transportation.
Yes, you're correct.
And in both of those hearings, your testimony was adverse to On Location, is that right?
Yes, that's right. And Your Honor, I just wanted to confirm, is it a cross-examination or it's a direct examination in Mr. Jennings' case?
The questions he's asking right now?
Yes.
So this is cross-examination in your case.
Okay, then I would like to object to lack of relevance. We just asking questions completely about something I did not testify before in my direct examination.
So Mr. Jennings, I agree. I'm going to overrule. If you're setting something up that he did address in his direct, I'll allow you to do that, but You need to be more focused on what he addressed in his direct examination.
Understood, Your Honor. You talked about a certain number of days. You just talked about that about 2 minutes ago. Do you recall that?
Yes, I do.
So are you asking the commission to issue fines and penalties against On Location in this case?
Well, I didn't ask for that yet. I just stated the fact. But to answer it, I'm planning to, yes.
Okay, because you filed a complaint against On Location in June of this year, right? The second complaint.
That's right.
Okay. You asked questions, well, have you contacted the commission about the transportation broker rules?
Several times. And I did lots of research on that.
So you contacted the commission staff?
Yes, over the since 2011 that we've been working with PUC, we contacted several times to clarify some rules, or to we would go on the meetings, that's the Zoom meetings where PUC talks about those rules. I watch lots of YouTube videos from I'm sorry, I forgot the name. But PUC staff actually talks about rules and regulations and how they apply. So yes, I did several times over this 14 years.
Okay. You talked a lot about things that happened after May 29th, 2025, which is when Judge Adams issued his decision, right?
I didn't talk to PUC about specific problem because I know.
Well, Mr. Lysenko, that's actually going to be my next question. So after May 29th, did you contact the commission staff regarding compliance with Judge Adams' order? Yes or no?
No.
What was your answer, Mr. Lysenko?
Answer was no.
And you are, I know we've had cases together. It's fair to say you're pretty experienced with how to contact the commission staff if you had a question or concern. Is that right?
Yeah.
If you had a question or a concern, do you know how to contact the commission staff?
Oh yes, definitely.
Do you
Mr.
know how?
Lysenko, I'm sorry to interrupt, Mr. Lysenko. You should speak up just a little bit, maybe move a little bit closer to your microphone, because your answers are getting a little bit lost, and you both need to focus on not talking over top of each other as well. So please help Ms. Boulay get the best transcript possible. So go ahead, Mr. Jennings.
Okay. I guess just to clarify, Mr. Lysenko, after May 29th, you did not contact commission staff about On Location's compliance with Judge Adams' order. Is that right?
That is correct.
Okay. And you're aware that you can contact commission staff if you have a compliance question or concern. Is that right?
And Your Honor, I did not testify. I'm not sure why we go in there. It was kind of ask and answer question, and we just keep beating up this dead horse. And I did not. So
I understand you're saying it's outside the scope of your
yes.
direct.
Yes.
Okay. Again, Mr. Jennings, I'm going to overrule this. It is, outside the scope of the direct, frankly. So you're going to need to be more focused on that. If you're setting something up, I'm willing to give you a little bit of room here. So please proceed.
I believe Mr. Lysenko has answered those questions. I have no further questions, Your Honor.
Okay. Thank you. And Mr. Lysenko, I don't have any questions for you. Do you have any redirect testimony that you'd like to provide?
No, Your Honor. Thank you.
Okay, thank you. So we will move on. Mr. Lysenko, do you have any other witnesses?
No, Your Honor, I do not.
So are you resting?
Yes, I am. I do rest my case.
Okay, thank you. Mr. Jennings, what do you propose? Do you want to start with your case now? Or would you like to, we're at 11:42. We can take an early lunch break. Or we can just move on from here.
I don't believe we have a preference, Your Honor. We're just going to call, well, we're calling Mr. Bowtie. We may call Mr. Lysenko. So potentially two witnesses.
Okay. So in any event, it sounds like Mr. Bowtie would be your first witness.
Correct.
So why don't we go ahead and do that? So Mr. Bowtie, welcome back. So I swore you in previously, and just that continues to apply now. So with that, Mr. Jennings, you may proceed.
Mr. Bowtie, you told us previously your name and your title and who you are. Can you tell us more about On Location's business? What On Location does?
Yeah, On Location partners with different music festivals, sporting events, music tours globally, and provides hospitality, transportation, travel solutions for these events. Lots of times for safety, lots of times to add revenue. That's the nuts and bolts of our business.
So quick clarification, what does hospitality mean in that answer?
We do a lot of VIP services. So similar at Red Rocks, we do a lot of travel packages, VIP up in their rock room, work with different artists to provide those sorts of services as well.
Okay, thank you. Sorry, Mr. Jennings, you can proceed.
And Mr. Bowtie, just tell us sort of the geographic scope. Do you work outside of Colorado? Tell us where your company does business.
Yeah, we're a global company, publicly traded. I focus on North America, and our company, my team traditionally and currently runs some of the largest shuttle programs for temporary events in North America.
Okay. So do you deal with transportation service outside of the state of Colorado?
We do.
And then here within Colorado, do you oversee the team working on the Red Rocks program?
Yes, I do.
And so do you oversee the employees here in Colorado?
I do.
Okay. Just tell us a little bit, please, about the history of On Location operating in Colorado.
Yeah, so I began with the company CID Entertainment about 15 years ago, which was purchased by On Location. We were the company that originally started the Red Rocks Shuttles program. That was originally came out of our operations around providing services to artists at Red Rocks and having a team that serviced those events in the area. It originally started with a lot of transportation or a lot of travel, a lot of VIP services. And eventually we saw the need to, get people off the road and to move people up there via shuttles. And that was in 2015.
Okay. Do you recall around the time when On Location acquired that existing business?
I would say it was maybe a year to 2 years after that. Yeah, I can't confirm, but it was either 2016 or 2017.
Okay. And So roughly how long have you personally been involved with Red Rock's transportation at the prior company or the current company?
I've had the team that's been running it has been under me since the inception.
So 10 years or so?
10 years. Yeah, it started in 2015.
We're here today about compliance. And outside of these two complaint cases that we are in with Mr. Lysenko, has the PUC staff ever contacted you about a compliance concern?
They have not.
To your knowledge, has the PUC staff opened an investigation or filed any complaints against On Location?
Not to my knowledge.
Okay. What about any other government agency in Colorado?
Not to my knowledge.
And when it comes to your customers, have any of your customers contacted you saying that they don't believe you're in compliance with Colorado rules?
They have not.
Are you aware of other tour companies or travel agencies that have a similar model to On Location?
I am.
Have any of those entities contacted On Location saying that you're out of compliance?
They have not.
And you already testified earlier, so just to make clear, are you personally familiar with the facts involved in both of the complaints by Mr. Lysenko?
I am.
And are you familiar with the ruling by Judge Adams that we are discussing here that was issued in May?
I am. Yes.
And are you familiar with the company's response, the responsive actions that you have taken after that decision was issued?
I am.
Okay. Ms. Crane, could you please pull up hearing exhibit 200? Thank you. Mr. Botai, could you take a look at this document and let us know if you're familiar with this document?
I am familiar with this.
Can you tell us what it is?
This is a version of our website from about 12 to 18 months ago, maybe the fall of last year.
Okay. Are there dates on there? Could you point us to how you know that?
Yes. So September 9th, 2024, I see there.
Okay. And is this On Location's website?
It is.
Is this the original?
I'm sorry, Your Honor, I would like to object on that. I did skip a couple questions when Mr. Jennings went back in the past, but obviously this exhibit is from the past, right? It's been in the previous proceedings. We're talking about exhibits. We limited the scope from May 29, 2025 and up to today's date. So it's outside of the scope of the hearing.
Understood. I'm gonna overrule and allow it. Mr. Jennings, I'm assuming that you're setting this up to show me the differences between then and now.
That's correct, Your Honor. You know, yeah, that's correct.
Okay, so
And we
it's
just have a
admitted-
few exhibits to get through in that regard.
Understood. So it's admitted, you may proceed.
Mr. Botai, just to clarify there, is this the original version of the website that On Location had up when Mr. Lysenko filed his first complaint in 2024?
It is.
And does this version of the website have any advisements or disclosure about third-party transportation providers?
Not to my knowledge.
Does this version have any notices about On Location being a transportation broker?
Not to my knowledge.
And to your knowledge, is this version of your website what Judge Adams found the company in violation of?
It is. Or I'm sorry, I retract that. It is not, because we had made updates prior to that May 29th ruling.
Okay. So did you make changes to your website after the version that we're looking at on the screen here?
We did.
Okay. This exhibit was omitted. Ms. Crane, could you please pull up exhibit 201? Thank you. Mr. Botai, can you tell us what this document is?
This is our website as of the 14th of March, 2025.
And how do you know what the date is of the version of the website?
You can see that at the top left here.
Okay, there's a date and timestamp.
Yeah.
Okay. Is this a different version of On Location's website than we just looked at with exhibit 200?
Same URL, same web link, but we have changed language at this point. If you were to, I believe, scroll down, there's disclaimer language that had been added by the March 14th.
Okay. Ms. Crane, do you mind scrolling down a little bit?
Honor, I would have to object on that. Again, this is exhibit 205 that was admitted in the previous proceeding. It's been already in the decision. It's already been discussed in the proceeding, in the previous decision. And we already took the administrative notices and all the evidence from that proceeding. So it's duplicative.
Understood. Thank you, Mr. Lysenko. So, Mr. Jennings, you're offering this as hearing exhibit 201 in this proceeding, right?
That's correct, Your Honor. And it is the same exhibit. What we do need to establish, though, is the before and after with respect to On Location's advertising.
Understood. So it is duplicative, but I'm going to overrule the objection and let you get it in. So it's admitted, and it's going to help me so that I don't have to refer back to the exhibits in the previous hearing. So I'm certainly hopeful that you're not going to admit every single hearing exhibit from the previous proceeding.
We are not, Your Honor.
Okay, so it's admitted. You may proceed.
Okay. Yes, Ms. Crane, do you mind keep scrolling down on page 2 there? Thank you. Mr. Botai, tell us what we're looking at here on your website on page 2.
This was the original disclaimer language that we had added, which was the main update at this point. It's seen throughout different points of the purchase process. We called out that we work with third-party transportation providers in pursuant with the applications, which we've read over before in this meeting.
Okay. Mr. Lysenko just asked you about what happened in the prior case. Is this the version of the website that Judge Adams said shows a good faith effort in attempting to achieve compliance?
Yes.
No further questions on this exhibit. Ms. Crane, could you please pull up exhibit 202? And Mr. Botai, could you tell us what we're looking at here?
This is a purchase page from when you go to purchase a package from CTIX, which is our purchasing platform, as of it looks like It says in that scroll bar there, March 28th, 2025.
Okay. And I believe this is the final one, Your Honor. This was an admitted exhibit in the prior complaint. It was exhibit 206 in that case, and we marked it as exhibit 202.
So are you offering it?
We are.
So let me just ask, Mr. Bowtie, you just cited a date. Was it March 28th, 2025? Is that what you said?
Yeah, I see that up here in the top right corner of this exhibit.
So is that the date of this, that this exhibit was created, basically? I mean, it's a screenshot. Is that the date
No,
of the
that is a
screenshot?
great point. Yeah, that actually looks to be the date of the event.
Ms. Crane, could you scroll down? Okay, so Mr. Bowtie, doesn't sound like you know the precise date that this screenshot was created.
I do not from this, but I can tell you it was before that, the date of that event in March 28th, 2025.
Okay. Mr. Lysenko, it's been moved for admission. Do you have any objection?
Scroll up, please. Once again. My problem with that is the page is incomplete. It's cut up there. So I'm not sure what's out there. The exhibit is not like complete. We don't know what's up there, what's hiding up there behind that header. So that's, it cannot be, it's not inadmissible evidence.
And
Just
Mr.
understood.
Lysenko, could you keep your voice up, please? You're dropping.
Yes, sorry about that. So yes, I do object on admissibility grounds.
Okay.
Just to respond, Your Honor, briefly, to clarify for everyone, the stamp on the top right is the stamp from the prior case where this document was admitted. And we can take administrative notice of it, like the contents of the other files. However, we thought for convenience, and I'm going to ask Mr. Bowtie either way about the practices surrounding the website at this time. So that's why we're asking for admission of this exhibit.
Okay, so I'm going to overrule the objection and admit it. I'll assign the appropriate weight to this exhibit in light of its incompleteness. But go ahead, Mr. Jennings.
Okay, thank you. Mr. Bowtie, just picking back up, this is for a specific Red Rocks concert in March 25, is that right?
Correct.
And is this page consistent with how On Location would have been advertising for other concerts at the same time?
Correct. This is the purchase flow for all concerts via this purchase process.
Okay. And Ms. Crane, if you could just scroll to the bottom there. Mr. Bowtie, is there an advisement on this web page regarding On Location working with third-party providers?
There is that last paragraph.
And to your knowledge, is this exhibit and this practice, did this exist at the time when Judge Adams issued his decision saying that On Location was making a good faith compliance effort?
Was that yes, Mr. Bowtie?
Yes, yes, it did.
Okay, thank you.
I'll speak up.
Okay, thank you. We'll move on. We just have a few more exhibits. Exhibit 203, Ms. Crane.
Well, let me ask you this, Mr. Jennings. How much more time do you have with Mr. Bowtie? Do you think we're at noon? So if you only have 5 to 10 more minutes, if Miss Boulay is okay, I'd say let's go for it. But if you have more than that, we'll take our lunch break at this point.
Okay, it might be a little bit longer than that, Your Honor.
Okay, so let's go ahead and take our lunch break. It's, as I said, noon. We'll be in recess until 1 o'clock. So we'll come back at 1 o'clock. Thank you.
Thank you.
Thank you.